Start with Dr. Ben-Ari.
You today sharing what I believe to be a significant step in INGO-related scholarship. I would like to say a few words about the topics we're discussing in the context of the ongoing discourse on the normative position, that is the legal status, of INGOs under international law. I believe this perspective can shed light on the importance of focusing contemporary research on the themes discussed in the book, both academically and practically. It would be difficult to imagine an intellectually more stimulating subject than the legal status of INGOs. It has its roots in a long and varied history and leads on to the most topical and concrete problems of world structure. The task is no less than to identify the future foundations and principles of the relations in international life between private enterprises and the action of public authorities. But however fascinating the subject may be, any solution to the problem is, as it always was, extremely difficult to find. Not only because it implies a network of technical problems, very hard to conceive and to implement, but above all because any change in the existing legal structures has political implications whether we like it or not. Well, these are not my words, but the words of Professor Merlet from the University of Paris, who reported in 1983 to the Parliamentary Assembly of the Council of Europe on the complexities involved in considering the legal status of INGOs. At that time, it was generally acknowledged that the issue has to be examined from the point of view of reshaping the structure and organization of the international community, and that the rise of the so-called transnational private sector, characterized by spontaneity and variety, constituted the genuine challenge to the association of nation-states. 30 years later, the topic still remains as fascinating and stimulating and as difficult to solve, legally and moreover politically, as it was then. Nevertheless, this August, the newly established Non-State Actors Committee of the International Law Association, the ILA, will reconvene to promote its current project that deals with the position of non-state actors, and INGOs in particular, under international law. Eventually, as the committee's 2010 report revealed, this project will aim to propose a normative framework to facilitate the acquisition of international legal personality by INGOs so that they can become genuine subjects of international law and the Euro participants in international law processes side by side with nation states, the original members of the international legal order. Probably very few of the ILA committee's current members are aware of the fact that more than a century ago, in 1910, the ILA itself was the first to consider the very same undertaking, suggesting the adoption through a diplomatic convention of a supranational status for the benefit of INGOs. That started a 100-year sequence of attempts by various international forums and institutions, both intergovernmental and non-governmental, to ameliorate the formal status for INGOs under international law. Clearly, within our confined time framework here, it is impossible to review the many proposals and reports issued along this sequence. It is sufficient to note that along the way, numerous obstacles have arisen, while hardly any solutions have been found. After all, the problem is very complex and serious indeed. How and to what extent do we translate international socio-political reality, that is the growing impact and burgeoning numbers of INGOs, into international legal arrangements? In other words, how do we turn international actors into subjects of international law? What would be a good enough reason for such a difficult endeavor? The number of such actors, their impact, their accountability? Prominent among the difficult questions that have arisen in the past and remained unresolved until this very day were those of registration, selection, and supervision of eligible organizations. In later years, they reappeared in the form of issues regarding the definition of INGOs and more recently, their responsibility and accountability. Proven to be politically and legally insoluble hurdles, we still do not have an agreed upon definition of the international non-governmental entity. Today, Against the background of heated discussions about the future of international governance, there is renewed interest in INGOs' legal position. In the age of INGOs and globalization, some international lawyers are encouraged by the invention of models and notions that endeavor to explain the complexities of global interdependence, being dissatisfied with the fact that INGOs do not fit neatly into existing legal rubrics and doctrines. These scholars might be anxious to apply new concepts borrowed heavily from the fields of political theory, political economy, and in particular international relations in order to suggest transformative initiatives or downright normative revolutions that would officially incorporate the INGO actor into the international legal order. In this context, legal status is seemingly required to facilitate INGOs' cross-border activities by the provision of rights, privileges, and immunities. This quest is occasionally based on a call for the establishment of a more fair international legal order that would reflect the position and relevance of all significant international actors, including INGOs, thereby legitimizing their voice and ensuring their participation. In most cases, as is with the ILA current initiative, this quest reflects an optimistic view of an angelic community of INGOs collegially networking to achieve laudable goals and rendering morally merited services for the global public good. This view rests on the assumption that INGOs' involvement makes international decision-making more effective, that INGOs provide significant democratic alternatives to existing channels of political representation, and do not act out of self-interest, and that, unlike governments, international institutions, and their officials, they are civilized, in agreement, and immune to corruption. However, these assumptions are far from being empirically verified, and are therefore still based more on belief than on knowledge. Furthermore, even the meaning of ideas and notions that provide intellectual backing for those assumptions, such as global governance, global civil society, and deterritorializing processes of globalization, the meaning of these notions is still unresolved, bearing varying interpretations. Certainly, these concepts do not portray an intellectually coherent picture or represent any straightforward truisms. INGO's legitimacy must therefore be earned on an individual, case-by-case basis. It cannot be assumed a priori due to the existence of a networking, representative global civil society, which beyond an intellectual construct for conveying legitimacy, does not exist in the form of a cross-border, cross-sectoral, overarching unity that promotes international relations and the rule of law. Certainly, such a notion and related assumptions would not feature any serious normative scheme for the articulation of INGO's legal status. Furthermore, as was realized in the very early initiatives towards a formal status for INGOs, and as has become more and more apparent in the last few decades, by and large, INGOs should be valued as sometimes very powerful, political, self-interested actors. Some leading INGOs, participation of which was initially based on the provision of their expertise and proficiency, repeatedly prioritized issues such as campaigning and advocacy instead of relief and charity. Some are accused of not denouncing violence or even of supporting terrorism. International lawyers must therefore realize that INGOs can be either good or bad. They can potentially facilitate international cooperation and the rule of law, but they can also obstruct them. These very acknowledgements, simple, albeit fundamental, underline initiatives such as the London Guidelines. Moreover, they are indirectly endorsed by leading INGOs themselves in seeking to establish frameworks such as the INGO's Accountability Charter. These are exactly the reasons why focusing research on INGOs' fact-finding and reporting capacities may suggest a new alternative channel for the progression of the discourse on the normative position of INGOs. In fact, it may prove to be a turning point, even a breakthrough, academically as well as practically, after nearly 100 years that yielded hardly any progress in that respect. It seems that we have reached the point where discussion of the normative status of NGOs at large has become too abstract, based on beliefs more than on facts. The academic discourse in this regard is at a standstill, confined to scholars' predetermined conceptions of the international legal order as being either universal or statist. The study of NGOs' human rights and humanitarian fact-finding and reporting, on the other hand, bypasses the complexities of the general debate on legal status of NGOs. It is not based on any a priori broad normative legitimacy assumptions, but on output and regulatory legitimacy considerations. It singles out a certain function which can be related to and evaluated on a case-by-case scientific basis, instead of considering a certain unresolved movement as a whole that cannot be reduced to concrete components and may bear conflicting historic and normative interpretations. It is not focused on defining the prototypical entity which performs a certain activity, but on outlining and regulating the activity itself. It is founded on a careful practical observations underlining a sector-based functional approach for the consideration of the position of certain NGOs, defined by the quality of their actual output and not by any self-stated mission. Altogether, such an approach acknowledges the need to respect NGOs' independence and integrity due to their distinctive position and expertise, taking into account their unique features as being self-appointed and officially unaccountable. However, it also recognizes their general need to gain credibility and legitimacy. All in all, by distinguishing the question of function from that of status, the way is open for the construction of an objective,